obtained. At the bill stage, my lord, it can be referred under 201. If 201, the president grants approval, then it becomes a law. 254 will not make it repugnant. But the other way of doing it is the state legislature can request the president to grant assent, make it a law, and then because repugnancy will make the other provisions unworkable, request the governor to send that part of, but once a law is made, it might be difficult, for it to be sent to the president thereafter. So, in my understanding, subject to correction, at the bill stage, usually 200, 201, it goes before the president. If the president grants approval, then it becomes a law. Equally possible, I'm dealing with it in the justiciability part of my submissions, that the president may, after being advised, by the Union Council of Ministers, say, no, we want to have a uniform policy throughout the country, not in a matter like Essential Commodities Act. We are not agreeable to this state having a separate legislative environment in a particular geographical area. So if the president refuses on the advice of union ministers, then the central law will continue to operate by virtue of 254.
What was suggested in 3.13 to 3.15 is inconsistent with what has been argued from your side.
No, my lords. Yes.
Probably study you are not here, that's why.
No, if I
may. You are insisting for a formal declaration, the argument was otherwise. We are only pointing out that from your side. The argument was that there is no requirement, there is no concept of a formal declaration
of withholding of.
Yes. Correct. Yes, no. Some of the states have made that submission, but my submission is.
Your 45 minutes.
Another 10 minutes, I'll finish.
No, but then we have to.
Yes, no. No, just 10 minutes. I'll very quickly run through this. But page 1335, what I have done, I'll not read this now, note for your lordships. What I have done is this power under Article 200 and 201, or the provisions would have to be operated, in relation to the three lists separately. If it's a union list, the union list, Article 246(1) itself says that the power to legislate is exclusively vested, with the Parliament. So state cannot make a law in relation to union list. So, if a bill is passed by the state legislature in relation to a union list, there would be no power available to the state legislature. It's ipso facto invalid. It will be void ab initio. If needed, a court will declare it to be invalid. Now, this does not require the governor to exercise discretion either to send it back to the House or send it to the president for consideration, because the president also cannot grant consent for making it valid if it is entrenching into list 1. So if list 1 is something that does not require this method of referring it to the president, it will not be applicable. If it is a state list exclusively reserved, 246(3), exclusively reserved for the state, the union parliament ordinarily would not have any power to legislate on those particular areas. But what I have done, at page 1336, I have indicated, and I'm not reading this, that the Constitution itself makes provisions that whenever, the Constitution wanted the power of the state to legislate to be subject to the union's power to legislate in legislative field areas, there are a series of articles which my lords entries, at page 1337, where in list 2, the legislative field itself is made subject to the union's power to legislate or subject to laws made by the union in this particular behalf. So legislatively, while they carved out certain area for the state, within the carved out area, they also had certain caveats with regard to where the state, the center can come and legislate. If it is otherwise left to the state, legislatively, it is for the state legislature to make this law completely on its own. If such a law is made, the governor cannot sit in judgment and say, this is either not desirable or the current circumstances do not make it feasible for having this particular law at this point of time. There is no point of referring it to the president under Article 201 in relation to a state subject, because the president and the union also in the executive sphere have no power to stop a state from legislating on a state subject. The Constitution was mindful that there may be situations when the Union Parliament may have to be given power to legislate on state subjects. My lord, at page 1338 onwards, my lord, Article 249,
When
250.
some of the states make a request jointly.
Correct. My lord, also, my lord, Article 250, my lord, if proclamation of emergency, 252, when two or more states request. My lord, also, my lord, 253, to giving effect to, my lord, any international treaty. My lord, I have set out all these articles in my note. Now, this enables, my lord, that the Parliament in its legislative space can make a law in respect of a state subject area. So if Parliament, my lord, can do it, it may do so, and it will be for a limited period of time. The Constitution was mindful, my lord, in which circumstance it will extend for which period of time, unless, my lord, it is where more than two states are asking for it to be done, or the Council of States by 2/3 majority requests the Parliament to do it for entire India. So, my lord, if in the parliamentary space, legislative space itself, if the center cannot, my lord, infringe on the state's rights to legislate, in list two subjects, my lord, my respectful submission is, the governor, my lord, either cannot withhold for the purpose of reconsideration or send it to the president. My lord, the only other area would be, my lord, the concurrent list area. To avoid this repugnancy, I've already made my submission, my lord, that this concurrent list area, it would be, my lord, at the request of the Council of Ministers. Even if the governor were to find, Council of Ministers thinks, my lord, it is not entrenching into any central subject area. The governor were to form an independent mind that this may entrench, it may need consent. But he is not sitting in judgment on the legislature's views or wisdom, because he would then have to give assent. If it has to fail, it will fail on the anvil of, my lord, judicial review proceedings that may come up before the court. So for all the three lists, when your lordships were to look at it separately, but Article 200 does not enable the governor to either withhold assent for the purpose of reconsideration or sending it to the president. Sending it to the president, my lord, the governor cannot, as I use an expression, my lord, extra constitutional advisor to the state legislature. When the state legislature says, no, it doesn't, my lord, trammel into the central government's legislative sphere, say that, no, I think it does, and refer it to the president. My lord, then justiciability is one last aspect, very quickly, my lord, I'll touch upon. My lord, page 1342, my lord, when a bill is sent to the president in relation to, my lord, a concurrent list area or the other provisions of the Constitution where the consent of the president is needed. My lord, if the president, my lord, feels on the advice of the Union Ministry that it is not desirable, my lord, judicial review in my respectful submission is permissible. Because what happens, my lord, if the president were to grant assent to state A for an identical provision, but were to say, I will not grant it to state B for an identical provision, my lord, then it would touch upon the aspect of discrimination. In a judicial review space, my lord, the court may interfere with it. But on justiciability, suppose, my lord, the governor were to say, no, we feel we need to have a uniform policy, or the conditions in this particular state are not enabling the union to have the confidence that there can be a departure from the central law. My lord, that on the fact situation would be dependent upon those factual situations where justiciability may be difficult. So it cannot be, my lord, one common situation where it is not justiciable. Judicial review is permissible. Justiciability depends on a fact-to-fact case and a situation-to-situation basis. My lord, I have just made this submission in three parts. My lord, last submission, my lord, on timelines. My lord, it's already been covered, but I'm only submitting, my lord, that in terms of your lordship's advisory jurisdiction space. My lord, since the my lord, the presidential reference has been made with specific questions on this point. My lord, if your lordships were to form a clear opinion that this has to be done with expedition, and this is to be done within a particular time frame, my lord, that is, as I indicated yesterday, your lordship's view of how time frames or whatever time is a reasonable time for the exercise of discretion, that would still be your lordship's advisory opinion. But that advisory opinion, my lord, in my respectful submission would be binding on the president, and instructions would have to go to the governor. My lord, only two, my lord, yesterday I had mentioned about this judgment. I'm not reading it. If my lords would want to make a note. My lord, in that special references case, 19, my lord, this is at volume 5.9, page 3661. My lord, just three paragraphs, my lord, I'm requesting your lordship's attention to.
Where have you referred to in your note?
My lord, this is there, my lord, in 6.1. No, my lord, this is not a part of my note. I had referred.
Volume?
Lord, volume 5.9.
Page?
My lord, page number 3661 is a citation, my lord, of 1979, volume 1 SCC 380. My lord, just 3 paragraphs, my lord, I am requesting your lordship's attention to. I am not reading it. Para 21, para 32 and 34. My lord, this 32 and 34 have not been read for your lordships.
On what issue?
My lord, this is with regard to, my lord,
Timelines.
para 21 is on a bill that is yet to be made. Para 32, 34, my lord, deals with how, my lord, there will be no encroachment into a legislative space by your lordships. If your lordships were called upon to render an advisory opinion and your lordships render an advisory opinion. So today, Article 200 and 201, apart from timelines, your lordship's opinion is sought on whether there is a discretion available to the governor, whether the discretion available to the president, in what measure is the discretion available. My lord, questions are also asked, are they justiciable? My lord, then the last of the questions is, are there any timelines that would be governing? So, my lord, my respectful submission is, staying in the space available to the president and the governor under Article 200 and 201, they are seeking your lordship's opinion. Since they are seeking in the space available to them, at their invitation, it is fully just and open for your lordships to give this opinion, which might be binding on them in terms of, my lord, your lordship's review process. My lord, I'm grateful.
Thank you.
My lord, I had mentioned about that notes to the Constituent Assembly. If I may just give the page number, it's 9312. The relevant part I've already extracted in my note. But just one last submission before my friend takes over. My lord, we have had tremendous assistance from the nodal council, but I can figure out, my lord, with the quality of assistance they have given, there have also been a lot of costs they have personally incurred, because all the volumes being filed into the court are being filed by them at their expense. And when we offered to pay costs, they said no, unless there is a formal order, it would not be possible for us. Lordships may.
Direct.
Yes,
No, my lord, I can vouch for both the nodal council of other side and my council, my lord. It is, my lord, a labor of love, my lord. Nobody would like to charge. It's an assistance to the court, and it's, my lord, and
No, not fees.
Cost for
Expenses.
even expenses also.
why
Your lord,
volumes and printing of so many volumes.
that's all right, my lord. It's an honor to be a nodal council before the highest constitutional court of the country, and the amount also may not be more. And I'm
It can be
speaking for.
distributed, it can be distributed by the state and all the governments.
My lord, I undertake the responsibility. Your lordships need not, my lord, bother. It's a small thing.
No, we'll.
Any of this one council appearance can bear the expenses. What is the problem there? Why should even this be? Mr. Simple is there, Mr. Reddy is there,
I take the
Ramanan
responsibility.
is there, Dr. Singhvi is there,
No need
Mr. Mehta is there.
Lord, I am taking the responsibility for the
I'll
expenditure
bear the
of
cost
both.
fellows on this side.
Yes.
No, this side, that side, I'll take the responsibility with
it on that side also, no issue.
No. I know you, Mr. Symbol is,
Far as the nodal council this side, but
No,
I
Mr.
myself have
Sibal is
written
very
to the Tamil
generous,
Nadu government
but-
to sanction and pay.
No, don't, let's not get into this.
yes. My lord, that, my lord, I'll take care of, my lord, for both sides. Your lordship need not bother. But it's very kind of Mr.
Reddy.
Mr. Reddy, my lord, to have flagged this issue. That's all.
Well, if you just look at my note, it is in volume 2.13.
He's appealing for the state, so.
Street, I have to be heard first.
But what are you going to argue? If you are going to toe their line, then we will not listen you from this.
No, we have certain different points. So Lordship, the Lordship kindly see 3 provisions of the Constitution. Article 244.
We are going by the sequence.
Let him, first the states and then the intervener.
I have something to say, my lord. I am not objecting to anybody arguing. But if your lordships are permitting even, my lord, strangers, my lord, to the issue being argued, my lord, I would personally feel, my lord, that let Mr. Wilson also have his day, my lord, for 10-15 minutes. He at least represents a political party which has a government in one state.
Grateful
But
to my-
individuals who have nothing to do are coming before your lordships and are, my lord, getting your lordship.
Lordship, individuals have to do very much,
my learned
and we can say in this constitutional.
My lord, you have right.
The citizens won't get hurt while this political battle goes on to and.
No, nothing like that. Lord,
No,
we
but
have
there are
some-
no-
Lordship, constitution, the document will define the politics
One
of the
minute,
country.
Sharma, 1 minute. 1 minute, Mr. Sharma. Don't raise your voice.
No, sir.
We'll run 10 minutes each.
Yes,
oblige.
yes.
Omelette, Lord.
Kindly see, my lord.
My lord, stranger in the sense, my lord, this is, my lord, state governments, etc., etc. My lord.
Let it, it's a,
Therefore, my lord, it was my duty, my lord, to say that if others are heard,
No, we are-
Mr. Wilson also.
We are going to hear Mr. Wilson also. If you are going to permit the other interveners, then.
Therefore, my lord, he could not have said it again.
And particular-
Therefore, I am saying.
And particularly when the live streaming is going on, so.
No, my lord, no.
Many of the arguments are only for the sake of live stream. If we stop the live streaming,
Crowd will listen.
My lord, I reserve my response, my lord, outside the court, my lord. But I have a very good response.
Your Lordship, the Article 244 of the Constitution, my lord, kindly see, because tribal
you are
area,
appealing for Meghalaya.
I'm appealing for Meghalaya, state of Meghalaya, my lord. Because there are certain unique features in 6th schedule and Article 244 conferring certain powers to the governor, my lord, which will have bearing, my lord.
Okay,
244,
Huh?
Article 244, sub Article 2, my lord. The provisions of the 6th schedule shall apply to the administration of tribal areas in the state of Assam, Meghalaya, Tripura, and Mizoram, my lord. So this Article 244(2), my lord, leads to 6th schedule, my lord, and 6th schedule, your lordship will see certain powers have been given to the honorable governor, my lord. Kindly see the 6th schedule, my lord, and more particularly paragraph 3 of 6th schedule, my lord. The regional council, paragraph 3, my lord, regional council for an autonomous region in respect of all areas within such region, and district council for an autonomous district in respect of all areas within district, except those which are under the authority of regional council, if any, within the district, shall have power to make laws with respect to items, my lord, are given. Allotment, occupation, use, and setting apart of land, my lord, that is item A. Then B, management of any forest. C, use of any canal, water. So these are the subjects, my lord. And kindly see sub-para 3. All laws made under this paragraph shall be submitted forthwith to the governor, and until assented to him, by him, shall have no effect. So the laws made by district council, my lord, are required to be placed before the governor. And this provision, my lord, paragraph 3, sub-paragraph 3, is not similar to Article 200, my lord, where the governor has 3 options: assent, withhold assent, and refer it to the president, my lord. In respect of these subject matters, my lord, governor will act on the aid and advice of the council of minister, either to give assent or not to give assent, my lord. There is no question of reference, my lord. Here, so my submission is, my lord, wherever the constitution wanted to provide the power to the governor to either grant assent or not to grant assent in unequivocal terms, it has said so.
That has already been argued at least
Yes, my lord.
1 dozen times. I don't know.
So
If you want to add something new, you may add.
yes, my lord, in the context of paragraph 3, my lord, because in paragraph 3,
Paragraph 3 is not for consideration before us.
yes, my lord, so
We are not we will be answering only what are the questions which are referred to us.
yes, my lord, and paragraph 9, where the governor is
That
exercising,
that provision is not for consideration before us.
my lord, what,
We have to answer what is referred by the honorable president to us.
yes, my lord.
We can't open a Pandora's box.
No, my lord, what I'm trying to submit, my lord, is in the context of Article 200, my lord, if your lordship will see the Article 200 talks about a marginal note assent to bill. If your lordship kindly see Article 200, it's the marginal note is also a key to understanding the
for interpretation.
Now, your lordship, kindly see the
When
marginal.
when the provisions of when the text of the article is very clear,
Yes, my lord.
do we need to go to the margin?
No, because what the issue which,
It's an additional aid.
yes, my lord, it's an additional aid.
When we cannot interpret the text as it is.
Yes, my lord. Now, what my submission is, my lord, this aid is required to be
What is the first principle of interpretation?
The first principle of interpretation is that the text is clear, my lord, then we'll have to go by the text, my lord. Now, the question which is falling for your lordship's consideration is that whether assent to bill has got three options or one option. Now, because if your lordship will see the marginal note of Article 200 is assent to bill. The marginal note is not saying consideration of bills, my lord. So the two other options, my lord, two other options, withholding the assent and referring it to the, or for reservation, referring the bill for consideration of president, my lord, are also, in my humble submission, my lord, are relating to the issue of assent to bill. Because this is in,
So what is your proposition?
my proposition is that the Article 200 provides for one option, that is assent to bill. And why do I say so, my lord? Is the reason is, my lord, that the issue, my lord, he assents to bill or he withholds the assent. Now, withholding the assent is for the purpose of formulating the message to the assembly, my lord, and after the message is sent to the assembly, then again the governor has no option but to give assent. So the marginal note, my lord, assent to bill, that is the only.
That is what everybody is arguing, that
No,
he has no other option
yes, my lord.
than to send it to the legislature with a message.
Yes, my lord.
And after that, if the legislature again passes the bill,
Yes, my
he has no other option than to get grant action.
yes. So then, placing my argument forward, my lord, because if the governor had three options, withholding the assent, my lord, it is part of the larger.
So according to you, also, the withholding is for a limited period,
Yes, my lord.
which enables him to send the bill along with the message to the legislature.
Yes, my lord.
And after it comes back from the legislature
Yes, my lord.
as it is, then he has no other option than to.
So assent to the bill, my lord. So then this is also an assent only to the bill, my lord.
That's the integral part of the assent only.
This is,
It's a comprehensive this thing.
yes, my lord.
Assent first exercises well and good, otherwise second and third are also part of granting assent later on
Yes, my lord.
by following that procedure.
Yes, my lord.
Either reserving it for the president or sending it back to the legislature.
I'm grateful, my lord. This is my precise argument.
Because of the marginal note, that assent to bill.
Yes, so,
Assent to bill is the very essence of the provision,
yes, my lord.
not withholding of it.
Withholding or consideration of bill, my lord, also because the marginal note would have said consideration of bill. But marginal note is saying assent to bill. So in my humble submission, it is a key to understanding these three aspects of the matter, my lord. So this is on the assent to bill, my lord. And my lord, if your lordship will see the second part of the Article 200, my lord, because if lordship will, the reference to the president also, my lord, a reference to the president. And there are three aspects, if your lordship will notice, in the first proviso of Article 200, the expression used is as soon as possible. But in case of Article 200, my lord, no such 201, no such exigency has been attached with the president to issue direction to the governor to return the bill. As soon as possible, my lord, is not mentioned in Article 201. So there is, my lord, so far as the reservation of bill is concerned, my lord, to the president, no such expression is used, my lord, regarding as soon as. Now, my lord, the point which I am trying to make, my lord, that as soon as the expression used as soon, in certain cases, my lord, for example, in 201, your lordship, kindly see 201. 201 says, my lord, when a bill is especially second proviso, my lord. 202 provided further that governor shall not assent but shall reserve for the consideration of the president any bill which in the opinion of the governor would if it became law so derogate from the powers of the high court so as to endanger the position which the court is of the opinion Court is by the constitution designed to fill, my lord. Now, in respect of this aspect, my lord, if you also will see, when a bill is reserved by the governor for the consideration of president, president shall declare either that they assent to the bill or withhold assent therefrom. Here, my lord, message is in proviso, provided where the bill is not a money bill, president may direct governor to return the bill. Here, there is no use of expression as soon as. Whereas in the case of article governor, my lord, expression used is as soon as, showing the expediency in matters which are not reserved for the consideration of the president. So there are certain areas, my lord, there are certain provision which can be reserved for the consideration of president, my lord. Articles are, my lord, which are Article 31A. I will not read those articles, my lord, because those have been placed. 31A, my lord, your lordship will kindly see 31A. And proviso particularly, my lord, because under these articles, the bills have to be reserved for the consent of the president. Article 31A, my lord. Proviso, my lord, provided that where such law is made by the legislature of a state, provision of this article shall not apply thereto unless such law, having been reserved for consideration of the president, he has received his assent. So 31A, my lord, then 31C also, my lord. Provided where there such law is made by, it's a, then, my lord, 254(2) also, my lord, if lordship will kindly see 254(2), because the governor, if it is taken, my lord, is bound by the aid and advice of council of minister, and the bill is passed by the legislative assembly, it is passed by the party which is in power, my lord. So if there is no discretion vested with the governor on this issue, my lord, 254(2), then the advice would by the council of minister to the governor would be not to place it before for reserve the bill for the assent of the president, my lord. So therefore, certain exceptions have been carved out, my lord, particularly 200, Article 200 proviso 2, my lord, and that 31A, 31C, and 254(2) also, my lord, where a law made by the legislature of state with respect to one of the matters enumerated in concurrent list contains any provision repugnant to the provisions of earlier law made by parliament or an existing law with respect to that matter, then the law so made by legislature of state shall, if it has been reserved for the consideration of president and has received the assent prevail in that state, my lord. So Mr. Reddy was placing this 254(2), my lord. So for the 254(2) also envisages the reservation of bill to the president, my lord, and also under Article 288(2), my lord. The exemption from taxation by a state in respect of water or electricity, my lord, and the legislature of a state may by law impose, and then Article 288 also envisages reservation of the bill by the honorable governor to the president, my lord. And last article, my lord, is Article 360, sub-article 4(a)(2), my lord.
Yes.
Yes, my lord. Article 364, sub-article 4, notwithstanding anything in constitution. Now, in the context of any such direction, it regard to, and the bill can be reserved for consideration. A small Roman 2, a provision requiring all money bills or other bills to which the provision of Article 27 apply to be reserved for consideration of president. So in all these matters, my lord, so there is no time limit, my lord. And as the expression in Article 201 does not contain as soon as possible, my lord.
Yes.
So my submission is, my lord, that the matters which fall exclusively in the domain of the president, my lord, no timeline has been set in Article 201. But the matters where
So according to you, insofar as governor is concerned, the timeline is there.
Yes.
Insofar as president is concerned, there is no timeline.
In respect of these matters, my lord, the items which are covered under the constitution, my lord, the inaction may not be there, my lord. Inaction in deciding one way, because the constitutional inaction is also a kind, there will be some decision on those aspects, my lord, but there is no timeline, strict timeline. Because, my lord, if I was going through the Hindi part of the Hindi version of the constitution, my lord, and in Hindi version of the constitution, what I found, my lord, the expression used for as soon is yatha sigra. Yatha sigra, my lord, is, if correctly translated, my lord, it forthwith.
Yeah, what did you say?
Yatha sigra.
यथा शीघ्र मतलब जल्दी
Yatha sigra. If I so, my lord, the Hindi
As soon as possible.
as soon as possible, forthwith.
stronger this thing forthwith.
I think, my lord, nothing turns on it, but yatha shigra possibly is as soon as possible. Forthwith, I'll just find out the Hindi word for forthwith, my lord.
So the
Turant, my lord, my learned friend is saying. That's Hindustani. But subject to, my lord, correct.
तुरंत प्रभाव से.
Pardon, what?
Official language, normally the word used is तुरंत प्रभाव से.
Turant, yes, tatkal prabhav se, yes.
so
with immediate effect तत्काल प्रभाव से with immediate effect.
With immediate.
जितनी जल्दी हो सके, my lord, that the yatha sigra not is जितनी जल्दी हो सके, as soon as is जितनी जल्दी हो सके, my lord, and yatha sigra in my humble submission is forthwith. So if I can please, my lord, unfortunately it is not part of my written
The
submission.
Constituent Assembly debates are in English, so while interpreting the words, we'll have to go by
My
what is
lord,
the text in the English.
yes, my lord, but this is also a tool to interpret, my lord. This is also an aid to interpret.
Translation, which is the judgment which shows that the translated version is a good judgment of interpretation.
Yeah,
Shows a judgment.
yes, my lord. This is
Any judgment which says that a translated version of a statutory provision is an external aid for interpreting that provision.
no, the point which I was trying
No,
to.
you are saying that it's an aid for interpretation, so
No, my lord,
suppose one judgment will draw.
no, my lord, in larger context, my lord, in larger context, my lord.
Indian version is an aid to interpretation. Yes.
Yes, we are also saying as soon as maybe is forthwith.
Yes,
We are
also
also-
in English.
That's the right principle.
It
Say that, no? It's maybe no dichotomy between the-
Official version of constitutional translation.
As soon as
How
possible.
can that be an aid to interpretation?
Yes, Mr. Amit,
Yes, my lord. Now, my lord,
you give a written notes, will come.
yes, my lord, one more point, my lord. 145.3, my lord. Kindly see my written argument, my lord, on 145.3, my lord, because that at page 336 of my written argument, my lord. No, on this-
So far he's on the right side.
Huh?
I said so far he's on the right side.
Written notes, at what page?
Yes, page 337, my lord.
Because having volume 2 point.
Volume 2. Volume 2. Volume 2.
Yes.
Your lordship will now under there, my lord, according to my lord, paragraph 80, my lord, the honorable, when hearing an appeal is obliged to refer any question involving a substantial question of law as to the interpretation of constitution to larger bench, provided two conditions are satisfied. First, this honorable court must be satisfied that the issue in question indeed raises a substantial question of constitutional interpretation. Second, it must be satisfied that the resolution of that question is essential for disposal of the appeal. Once both limbs of this test are met, the proviso use of the term shall render the referral mandate.
This is with regard to maintainability.
Yeah, with regard to the reference of that 140, whether it is and on middle, my lord, because, I borrow the words of learned solicitor. It is not adversarial because learned solicitor started the entire discourse with this submission that it is not adversarial, and we are assisting your lordship to come to the right conclusion, my lord. And so I have cited two judgments on this, my lord. Kindly see, and the Supreme Court rules also, paragraph 82, where Supreme Court rules are there, my lord.
Order 622.
Yes, paragraph 82 at page 5, appeal or proceeding. A bench considers that matter should be dealt with by a larger bench. It shall refer the matter to the Chief Justice, who shall thereupon constitute such a bench for hearing of. The repeated use of term shall in both the rules and enabling provision imparts mandatory force to the referral process, leaving no room for.
Anyway, we are not going to in that question whether the division bench ought to refer it to a larger bench or not. That's not an.
So, my lord,
question
your
which,
lord has considered this aspect in two judgments, my lord.
We are not considering that question as we are not on the correctness or otherwise of the judgment of the division bench as to whether they were not justified in referring it to a larger bench or not.
Because, my lord,
We are only answering the reference.
my lord, so
Yes, thank you, Mr. Amit, for it.
I'll place, my lord, my written arguments on this.
Yes, Mr. Wilson,
Yes,
10 minutes each.
yes. Grateful to your lordship, my lord. My lord, petitioner always, my lord, thinks of, my lord, participation in these types of matters. My lord, in order to assert, my lord, the state's autonomy and federalism. And my lord, I'm grateful to the learned Solicitor General, my lord.
Even otherwise, we are going to permit.
Yes,
We will
grateful to
be
you.
grateful to you.
Yes, grateful.
Then
to
if you are going to
you. Yes,
permit others,
yes, my lord.
at least because
Yes.
of the live streaming, then
Submissions.
yes.
Lord, I have divided into two parts. Lord, page number 1 to 11, my Lord, is a key to my written submissions. Volume 2.14. 1-4. Lord, this article, Lord, we have been wandering in this court for a longer period. Special reference. And my Lord, we know the pain which we have undergone, my Lord, in approaching the courts and ultimately, my Lord, getting an order in our favor. Lord, that is why, my Lord.
We are not going into
Yes.
the correctness
Yes.
or otherwise of the judgment
Certainly,
of the
my Lord.
division.
Certainly, my Lord,
We are only
I do.
restricting ourselves to the
Yes,
question.
I bow my head, my Lord. I am grateful to your Lordship, my Lord.
So don't
Yes,
don't
yes.
bring your pain before the court.
Lord, whatever may be, my Lord, today the states are celebrating this judgment. That's what I wanted to place it.
This is again.
Lord, yes. Now, my Lord,
You
let
are-
us see the legislative procedure. Yes,
When you argue a matter, it is expected that you
yes.
argue a matter with some sort of detachment.
Lord. Yes, certainly, my Lord, certainly. My Lord, I have to just place, my Lord, what has made us, my Lord, to come before this court. Now, my Lord, legislative procedure, this article 200 and 201, my Lord, falls, my Lord, under the heading of legislative procedure. Lord, this legislative procedure, my Lord, should be understood in the context of the Constitutional Assembly debates, rule of law, and, my Lord, the principles and approaches adopted by the constitutional courts. My Lord, therefore, this legislative process, my Lord, which your Lordship is going to interpret, my Lord, your Lordship has to take into consideration that the people's, my Lord, elect a government, my Lord, or a representatives, my Lord, with a fond hope that they will give good governance within 5 years. Therefore, my Lord, the legislative process should be fair, reasonable, uphold legislative supremacy, respect states' autonomy, support the federal structure, and promote parliamentary democracy. My Lord, that is what, my Lord, this 200, my Lord, altogether, my Lord, your Lordship has to look into it. So, therefore, my Lord, if your Lordship sees how, my Lord, Article 21, when the word, my Lord, procedure, Lord, is there in Article 21 is interpreted by this court in Menaka Gandhi. Lord, I have stated that, my Lord, in B. Lord, if your Lordship sees, I have enclosed that, my Lord, in page number 11, internal page number 11, 1506. Lord, Menaka Gandhi's case, my Lord, clearly says, Lord, at page number 1507, that the procedure should be fair, transparent, and, my Lord, addressing the functions of the governor, time limits and methods of handling bills, including reserving them for the president's consideration and setting time limits for the president's action in terms of constitutional scheme falls well within the jurisdiction of this constitutional court and judicial manageable standards envisaged in the Constitution. The Honorable Court is tasked with the ensuring that both the procedural and substantive validity of any legislation align with the constitutional provisions. This includes interpreting the relevant procedures clearly and ensuring the effective functioning of constitutional institutions, not constitutional institutions including governor. This in turn enables the upholding of rule of law, delivering good governance. That's very important. For a people, we go before the people, we get elected, we come and form the government, and we have to give good governance. That is very important, and within 5 years, we have to do it. And therefore, there's a meaningful participation by the representatives of the people. These elements are essential for maintaining parliamentary democracy. Therefore, this Honorable Court is well within the time limits to interpret the legislative procedures embodied in Article 200 and 201 as exercised by the Governor and the Honorable President. Then, my Lord, I have also said, Lord, at C, paragraph C, Lord, in my key to the written submissions, Lord, page 1497, a judgment of this court, Lord, in Roger Matthew versus South Indian Bank Limited. Lord, if your Lordship sees, Lord, page 12, I have extracted that judgment. Kindly see, Lord, page 12, 1507, para 11. Lord, in Roger Matthew, whether, Lord, the court can go into the test the legislative procedure. Lord, this court said, Lord, paragraph 11, I have extracted. Since the Constitution explicitly provides a self-contained detailed procedure for enactment of legislation and does not suggest that mere assent of the President to a law by whatsoever method adopted would become a valid law, it is necessary that this court, being the highest constitutional forum for judicial review, is provided with enough space for enforcement and protection of the constitutional scheme. Thus, a mere presidential assent does not validate a law by any method. The Honorable Supreme Court, being the highest constitutional forum for judicial review, must be provided with enough space for enforcement and protection of the constitutional scheme. Then, my Lord, I have also, my Lord, quoted Kaiser Hind, my Lord, 2002, 8 SEC, page 182.
Roger Matthew is with regard to the power of this court to examine whether the law violates any of the provision of the Constitution or not.
Not, my Lord, including the procedure, my Lord, which is set out in the Constitution. My Lord, because the procedure, my Lord, 200 and 201 comes, my Lord, under the heading procedure, legislative procedure. My Lord, my humble submission would be, my Lord, this court is empowered, my Lord, to see whether the procedure which your Lordship is going to, my Lord, interpret as per the constitutional debate, my Lord, is fair and reasonable, so that, my Lord, it takes into consideration all aspects. Then, my Lord, this Kaiser Hind also, my Lord, if your Lordship sees page number 11, my Lord, paragraph 12, my Lord, I have extracted this Kaiser Hind. My Lord, that relevant paragraph, my Lord, at page number 12, at paragraph 12, my Lord, para 29, my Lord, it says, we further make it clear that granting of assent under Article 254(2) is not exercise of legislative power of the President, such as contemplated under 123, but is part of the legislative procedure. Whether procedure prescribed by the Constitution before enacting the law is followed or not can always be looked into by this court. Therefore, my Lord, the granting of assent is not exercise of legislative power, such as contemplated under the Constitution, but it's a part of legislative procedure. And, my Lord, held that the procedure prescribed by the Constitution before enacting the law is followed or not, my Lord, court can always look into that. Then, my Lord, with regard to the immunity, my Lord, at page number 1497, my Lord, my Lord, I have said about the Rameshwar Prasad 2006 2 SEC, page 1, my Lord, where immunity available to the governor does not take away the power of the court to examine the validity. Then, my Lord, I have also extracted S.R. Bomey's case 1994 3 SEC, page 1, where, my Lord, judicial review is a basic feature of the Constitution. The arm of the court is long enough to reach injustice, and actions of every highest constitutional functionary is subject to judicial review. And if your Lordship sees, my Lord, state of Rajasthan, my Lord, that I have extracted, my Lord, at page number 14. If your Lordship sees, my Lord, page number 1509, para 15, the state of Rajasthan is very important, my Lord. Para 149 particularly, it says, this Honorable Court held that whenever a question arises as to whether a constitutional authority has acted within or exceeded its powers, it is a constitutional duty of the court to decide it. The Constitution is the supreme law of the land, binding on every organ of the government, executive, legislature, and judiciary alike. No authority, however high, can be the sole judge of the extent of its power under the Constitution. This court, as the ultimate interpreter, is entrusted with the task of defining the limits of power, ensuring that no branch transgresses them, and upholding the rule of law by enforcing constitutional limitations. Then, my lord, I have also extracted this Roger Matthew. Again, my lord, with regard to the interpretation of Article 212, my lord, to what extent, my lord, the court can go into the legislative procedure. My lord, if it is illegality, then, my lord, the court said, we will go into that. I have extracted, my lord, in page number 14. And so far as the judicial review is concerned, my lord, I have extracted, my lord, the judgments of this court, my lord, in fact, my lord, from paragraph 17, my lord, at page number 15, my lord, I have made a tabulations, my lord, SR Bomey's case, BP Singles case, paragraph 17, if your lordship sees, my lord, SR Bomey's case, BP Singles case, Kalpana Mehta's case, Rajaram Pal, State of Rajasthan, AK Kaul, Kaiser Hind. My lord, in all areas, my lord, there the judiciary, my lord, has interpreted, and that's how, my lord, the institutions are functioning. My lord, this is an area where, my lord, till, my lord, this Tamil Nadu state was Tamil Nadu governor fixing the deadlines. My lord, it was an area, my lord, where it was subject to interpretation. Now, my lord, that area is also settled. Now, if your lordship comes to, my lord, the questions, my lord, that is posed, my lord, by the honorable president, my lord, so far as question number 1 and 2, my lord, please come to page 3, my lord, of my keynotes. My lord, extent of power given to the governor. My lord, we are here, my lord, quoting Dr. B.R. Ambedkar's, my lord, speech. My lord, if your lordship comes to page number 18, my lord, I have quoted B.R. Ambedkar's speech, my lord. Where, my lord, he says, my lord, at page number 18, para 20, but where he says, yes, my lord, kindly come to 21, my lord. My lord, this is what, my lord, we expect. My lord, in fact, an assurance is given by, my lord, Dr. B.R. Ambedkar, my lord, when all states were coming together. The drafting committee felt, as everybody in this house knows, that governor is not to have any kind of functions. To use a familiar phraseology. Yes. Lord, this word was not read, that's why.
Already
Read, my lord, then I'll skip it, bro. Grateful to your lordship, my lord. Then, my lord, your lordship kindly come to, but how this article, my lord, 175 and, my lord, 91 was made, my lord, much argument is made. My lord, I am skipping that, my lord. And, my lord, my submission would be only that, my lord, there are only 3, my lord, ways, my lord, where it was argued much, my lord. And, my lord, always the governor has to act under the aid and advice of the Council of Ministers. Now, my lord, with regard to the false through, my lord, much argument was made on the basis of, my lord, Alluri Basavia Chowdhury. My lord, our submissions would be, my lord, the will falls through means bill dies where it is born. My lord, governor cannot withhold, my lord, bill on his own and bury it at Rajbhavan. My lord, as explained in the Constituent Assembly debates, it can be only exercised under the aid and advice of the Council of Ministers. And, my lord, why it is, my lord, sent back, withhold is, my lord, to remedy a hasty action, or when the ministry or the government changes before the bill is assented by the governor and a new ministry is
That is already argued.
Yes, that is argued. My lord, in fact, Samshir Singh, Nabam Rabia, my lord, Kaiser Hind says, my lord, at page number 35, kindly see, my lord, page number 35. My lord, this is a page number 35. Lord, they say, Lord, will is nothing but expression of political will. Apparently, the will of the people expressed through the legislation passed by their elected representatives. To that extent, Lord, I'm quoting this. And, my Lord, the governor, my Lord, he can't be a constitutional court, my Lord, that we have, many of them have argued. Now, my Lord, your Lord should kindly see one of the important submission is, my Lord, this federalism, Lord, ingrained into the constitution. Lord, what Dr. Ambedkar said, if your lordship comes to, Lord, page 37, Lord, I have extracted, Lord, Dr. Ambedkar. Our fear is, Lord, whether the federalism or a state autonomy is going to be lost. Lord, in the exercise of, Lord, interpretation of Article 200, kindly see, Lord, paragraph 40, what Ambedkar said. my lord, this is on 26th November 1949.
25th.
There is only one point of constitutional import to which I propose to make a reference. A serious complaint is made on the ground that there is too much of centralization and that the states have been reduced to municipalities. It is clear that this view is not only an exaggeration.
Already, we have read it so many times.
This is not read, my lord.
It is read.
Yes, my lord. Then I skip that, my lord. Then your lordship kindly, yes. Then your lordship kindly see, my lord, the time taken by the bill. my
Where
lord.
Dr. Ambedkar says that insofar as states are concerned, they have an exclusive right to legislate on them.
Partition, the power is partition between the state and the
Insofar as
central.
Parliament is concerned, this has been read so many times now.
Yes, and my lord, how the constitution has to work.
You had your 10 minutes
Yes,
now.
Lord, I will finish it off, my lord. My lord, if your lordship sees, my lord, the constitutional silence, my lord, courts have interpreted, my lord. Yes.
Mr. Wilson, the only new thing which, of course, no one has referred to is your diagram at 1527. So better you rely upon that.
Grateful to your lordship, my lord.
Colorful also. Colorful.
A colorful diagram, my lord. Yes, my lord. My lord, I will just skip, my lord, certain points. I'll summarize. My lord, I have said about the constitutional silence, my lord, which your lordship can interpret, my lord. This has been said in Krishna Kumar Singh, Jai Shri Ram Patel, Kesavananda Bharati, and K.S. Puttuswamy, my lord. This court has said, constitutional silence is a dark matter like dark matters in physics. These elements are not directly observable in the text, but without them, the constitution would collapse in incoherence. My lord, that paragraph, my lord, I have marked, my lord, page 46. Then, my lord, I have extracted, my lord, the judgments, my lord, where they said about the constitutional silence. And, my lord, because of this Article 356 interpretation in S.R. Bomai's case, today, my lord, we are saved, my lord, from indiscriminate dismissal of the, my lord, by the governors. And, my lord, if your lordship sees, my lord, this as soon as possible, my lord, the interpretation, what H.V. Kamath feared, my lord, that is a fear coming to us, my lord. That is a fear, my lord, that I've, my lord, stated in page 53, my lord, para 56. My lord, what will happen, my lord, if the timeline is not fixed? Then, my lord, I will be, my lord, wandering in courts. I have given a schematic diagram also, my lord. My lord, therefore, my lord, the court cannot be a mute spectators, my lord, and I cannot, my lord, court cannot be one of the layer between the governor and the act coming into force. Every time, my lord, I cannot come, my lord, I filed a writ petition in 2023. I'm giving one example. My lord, and 2025 only, my lord, the judgment was delivered. Nearly 2 years, my lord, I was wandering in the courts. Therefore, my lord, my humble submission would be, my lord, this timeline also, if your lordship sees, there is already a memorandum, my lord, which we have enclosed. Your lordship would kindly see, my lord, that memorandum at page number, Lord, 1551. This memorandum is extracted, my lord, in the judgment of Tamil Nadu government versus Tamil Nadu governor's case. This memorandum, my lord, passed by the central government, clearly says has got the approval of the cabinet, which says 3 months, my lord, the bill has to be disposed of. My lord, I have, my lord, enclosed at page number 1551. My lord, when the government itself, my lord, have decided to decide, my lord, all the bills within 3 months, and cabinet has approved. My lord, when cabinet has approved, my lord, it has got a flavor of Article 73. My lord, it becomes a law. My lord, what is difficulty now, my lord, in court saying that, my lord, within 3 months the bills have to be disposed. Therefore, my lord, they will not have any difficulty, my lord, in dealing with this because they already have a mechanism like this, but they are not doing it. Page number 1551, my lord, I have extracted that. So, therefore, my lord, my humble submission would be that the advisory jurisdiction, my lord,
Yes.
advisory, my lord, I am concluding.
Yes, you are
Concluding, my lord. Advisory jurisdiction, my lord. Only when, my lord, there is a law that arises for consideration, my lord, the president can refer it under 143(1). But here, my lord, there are list of laws, my lord, I have enclosed a list at page number 70. Kindly see, my lord, page number 70. All questions, page number 70. My lord, Tamil Nadu government versus Tamil Nadu governor is a complete answer for all, including, my lord, other cases. I have given all, my lord, the judgments, my lord, the questions raised in, my lord,
Thank you, Mr. Will. Thank you.
and, my lord, lastly, my lord.
Thank you.
Yes. Yes. And, my lord, this, my lord, why they say is, my lord, your lordship would kindly see these timelines. If the bill returned by the president, my lord, this is there at volume 28. My lord, this alone, your lordship may note it, my lord. My lord, why the timelines, my lord, was skipped, my lord, when Article 91 had 6 weeks? Is, my lord, they wanted, my lord, the bill as soon as it comes back. Yes. my lord, therefore, my lord, my humble
Thank you.
submission would be, my lord.
We are granted you 10
Yes,
minutes. You have
but
taken-
this judgment, my lord, that is in place, my lord, is really helping the states, my lord.
We are not concerned with the judgment. How many times we are telling
Grateful
you?
to you. All the judgments, my lord, I'm only referring to
How
all.
how many times we are telling you?
Grateful to you.
Don't get so much personally.
Grateful to you, lord.
Wait, please, Lords. Lords, if your lordships could kindly have volume 2.13, that's 1.3. In the soft copy, maybe better if your lordships can access that, because when you tap on it, it'll take you to the appendix which has references on the soft copy. But otherwise, the hard copy is fine now. There are a few points I have to make which have not been made so far. I'm not doing anything which has already been addressed. Can this be just handed up to you?
You are appearing for who?
There are two applications in which I'm appearing, 176467 and 175970. One is an advocate, the other is a former DGP of police. Both citizens, both wish to address your lordships on this. Yeah, I'm just handing up copies of this constitution, my lords, which has the previous provisions in the footnotes, which may be relevant.
You already have your,
I do it customarily before constitution.
every constitution
This
based
is the
on
latest.
how many copies we should keep.
I have done that. It's a latest edition. So if your lordship will just,
I can replace it with.
yes.
My lord,
In fact,
if we look
this
at the first
particular
page,
edition,
if
this
we look at the
particular
first
edition,
page,
if
my
you
lord,
look at
it's a
the
very
left
good.
side, the first page, you'll see the quote of Justice Vivian Bose from BD Supply. It is
Lord,
very,
if
very
your
important.
lordship sees the first page, well, it's an amazing effort by him, my lord, no doubt about it. But a layman would understand that rather than Dr. Ambedkar, Mr. Gopal Shankar Narayan has written this constitution.
Or Mr. Rahul Gandhi. So, the lordships can just.
Yes.
Now, my lords, in the constitution, just to start, just see Article 145, subclause 4 for a minute. One 145.4. This has not been read to your lordships yet.
145.
145, subclause 4.
No judgment shall be delivered.
Yes, if I can read that. No judgment, the word used is judgment, shall be delivered by the Supreme Court save an open court. Lords have, my Lord the Chief Justice. And no report. Please note the word report. This is very critical to this entire exercise. And no report shall be made under Article 143, save in accordance with an opinion also delivered in open court. So the Constitution envisages from day one that what your lordships are doing now is not a judgment. It is a report based on opinion. Now, because it says no judgment shall be delivered, save in open court, and no report shall be made as far as 143 is concerned. So the advisory opinion is a report, merely a report. What flows from that is a little critical for the purposes of your answering those 14 questions. So this is in fact a recognition of what took place before the Constitution came into effect. The Constitution took Section 213 of the Government of India Act. It effectively copy-pasted Section 213 into Article 143. The only addition were on questions of fact. Questions of fact were not considered by the federal court in its advisory jurisdiction earlier. So what your lordships are doing now is a completely different jurisdiction from the jurisdiction your lordships embark on in 32, 131, appeals, 136, etc. It's a completely different jurisdiction. In that jurisdiction, your lordships are being asked by citizen number 1 for guidance. Now, the way under Section 213 of the Government of India Act, this was referred to is relevant, and I'll tell your lordships the reason why it's relevant. That if for a minute your lordships will see Article 374 of the Constitution.
Article
374. Subclause 2 of Article 374. all suits, appeals and proceedings, civil or criminal, pending in the federal court at the commencement of the constitution shall stand removed to the Supreme Court, and the Supreme Court shall have jurisdiction to hear and determine the same. And please note this, the judgments and orders of the federal court delivered or made before the commencement of this constitution shall have the same force and effect as if they had been delivered or made by the Supreme Court. So, all those that were delivered by the federal court are effectively binding on this court by virtue of 374(2). The reason I mentioned this, and this is why I don't want to duplicate what has been said before, but I'm just flagging it. Mr. Datar yesterday mentioned the estate duties case, which is one of the 4 references under section 213 heard before the constitution came into effect under the Government of India Act. The estate duties case is very critical about what they say about advisory jurisdiction. There are effectively 3 judgments of your lordships which have dealt with what the advisory jurisdiction is and what the chapeau of that is. And the first one is the estate duties case then. The second one, so far you've had 15 references under 143 before this court. The very first one, Delhi laws did not deal with the issue, but the second one did, which is Kerala Education Bill. So there are many passages of Kerala Education Bill which look at estate duties, look at what the scope is. That same aspect of what the scope of 143, Article 143 is then considered by your lordships in the majority in Ahmedabad St. Xavier's, 9 judges. Noted, in fact, in the majority of Privy Council, Privy Purses, which is 11 judges. Noted finally by Chief Justice Chandrachud, and this has been referred to in the special courts act, both Mr. Reddy and Mr. Datar have referred to. What they say across this swath is as follows, and if I can just show your lordship that starting point, that's all I want to show your lordship from this. Just see page 1369 of this compilation, page 1369. And if your lordships are looking at the soft copy, your lordships may click on Appendix 1. Just tap on Appendix 1, it will take you to 1369.
1369
Of this same volume, my lords, my compilation. I put everything here. 1369. This is Chief Justice Spence of the Federal Court, my lords. My lord, the Chief Justice has it, 1369. The 19th
Yes.
page of the volume, yes. 1369. I'm reading from the bold portion, just the bold portion. It may be stated at the outset that when Parliament has thought fit to enact Section 213 of the Constitution Act, it is not in our judgment for the court to insist on the inexpediency, according to a certain school of thought, of the advisory jurisdiction. Nor does it assist to say that the opinions expressed by the court on the questions referred will have no more effect than the opinions of the law officers. This is Attorney General for Ontario versus Attorney General for Canada. That is the necessary result of the jurisdiction being advisory. So the role that is being discharged by the Constitutional Court in its advisory jurisdiction is effectively not more than that of what a law officer would do as far as government. Consequences follow from this. Now, if your lordships were to scroll down to page...
We will be only answering the questions.
Very well.
As to what is its effects or not, that's not for us to decide.
Correct. So now I'm just in the...
Whether it has a binding force.
Correct.
Or it is only an opinion of a
That's
law
That's
officer.
already been decided. That's already been decided.
As and when the question arises,
Somebody will decide.
No, the
It's
question,
not,
the
your
question
lordships
has
are,
arisen.
Lord, I have a serious objection to this. Your lordships are not making a report to the president. Please read the language. Report containing your lordship's opinion. Your lordships never report to anyone.
No, I'm
The
not saying
honorable
report to-
president, which my learned friend referred to
I don't
as
think he
first
understands.
citizen,
It's a
is
con-
the-
you meet that in your region.
yes, my lord, but
You reserve that for
you have
region.
to be respectful to the,
Again, we'll have to.
I don't need instructions
Yes,
from you about
that's-
being respectful, please.
Yes.
yes. No,
I don't
nobody
think these
can.
Unnecessary interruptions are
Nobody
necessary.
can.
It constantly keeps happening from the Solicitor General. Now, if you see that first page of my note, which is at page 1354, my lords, page 1354.
This point you can skip, Mr. Shankar.
I just want, there's a sequitur to this point. There's a sequitur. First, this has been decided fully. It's been decided not in a list. In Ahmedabad, St. Xavier's, it's been decided. In Privy Purses, it's been decided. So the question whether it's binding or not has been decided by 11 judges saying,
So we are not going to decide that.
no, I'll tell you the
We are
reason.
only answering the questions that are,
No, so the
Whatever worth it is, that will be tested somewhere else.
sequitur to this, I'll explain what the sequitur is. The sequitur, as a result of this, what is
If I argue-
opinion in the form of a report. Second, no list is decided, no dispute is adjudicated. As a result of this, my lords, provisions 141, 142, and 144 of the Constitution do not apply to advisory opinion. If it doesn't, the consequences are at the bottom of the page. What the court's approach perhaps could be in this particular case are as follows. First, that if you see that none of the 15 judgments of your lordships previously have referred to 145.4, none of them. None of the 15 judgments have overruled a previous judgment. None of these 15 opinions have been overruled subsequently. The consequence of that is that when 14 questions are put to your lordships, of which 10 questions, between 9 and 10 questions, are answered by a judgment of this court, the opinion that anybody would give when that question is put is effectively that these questions are answered in these paragraphs of this judgment and end the matter there, not reopen that further. In
that
fairness,
has already been argued.
correct. So
You said
there
that you are
are,
going to argue something new.
yes, so the something new will be with reference to those
Already,
questions which are recent.
You have already crossed your 10 minutes.
Very well, Manoj. If I won't take long. I'm just showing your lordships a few more facts. Come to the bottom of page 1356, please. 1356. Please note that this is not a recent issue. I told your lordships I'm taking a middle path. I want your lordships to know that this is an issue regarding reserving for
It doesn't appear to be that you are taking a middle path. On the contrary, you are taking a path which is more extreme than that is being taken by the
No.
I think with the states on this side.
No, the states on this side, I think, are all ad item on one fact. And I'm very surprised, Malad, that states should at all be on that side at all. Coming and saying, we'll pass a bill, but we want our governor to sit on it. That's a very strange position in my view for us.
It is for them to decide it.
Yes, it is.
They have not sought your advice.
Which is why, exactly. They have indirectly, Malads, unfortunately.
They have not sought your advice as to what they should do.
Unfortunately for us, Malad, we can only make our case here. We can't make it directly to the querist. The querist has lawyers. It's being made here. That's why. Manoj, the two submissions I'm making at the bottom of page 1356 are simply this. That if your lordship will just see that chapter, I'm not at leisure, please see that chapter. I've annexed it of Granville Austin. He details in para and verse how Chief Minister Moraji Desai in 1952 faced these problems, how from then on, state after state has been sitting on bills and there should be a solution. My submission is that solution has come. This judgment in the state of Tamil Nadu is that solution. It ensures that it's taken care of. In response to an argument that was made by Mr. Salve, that in the federal scheme, according to Mr. Salve, it is such that even if a state passes a bill, the central government via the governor can in fact prevent that bill from being passed. That was an argument that was made. That is answered in Hargovind Pant in that paragraph at the top of page 1357, which makes it very clear that the governor is not subordinate or subservient to Government of India. He is not amenable to directions of the Government of India, nor is he accountable to them. It's a constitution which has said this. So there is no question of that argument being countenanced in the least. My lords, your lordships have gone through the Shamsher Singh judgment, etc. On the interpretation of 200, there are three things which your lordship may please note. Just if you can see 200, three aspects which have not been shown to your lordship. So please see that. I acknowledge Mr. Vivek's
200.
assistance to me. Vivek said he couldn't make these submissions himself, so he's assisted me in this. Article 200. So please note three things.
He was heavily assisting You're standing next
No,
to.
no, my lord, he actually, in the sequence, he should have argued, but because I think the time is short.
No,
Article-
because we have, when it is a rule, there is only one
No,
concept.
no, I know. So eventually, my lords, because it's one client, the lawyer can't make that argument. So he's given me the argument to make. So if I just see Article 200, just please note at the end of that first clause, my lords, it says there's two things to be noted. One, it ends with a colon. That's very, very important. Right, my lords? Before the first proviso. At the end of that first proviso, there is one more colon. Now, in the indoor, I'm sorry.
So there's comma.
I'm sorry.
There's not a colon.
No, at the end of the next, first,
No,
end of the
You are
main
saying-
provision, there's a colon.
yes.
At the end of the first
after
proviso, there's a colon.
Yes.
Yes, main provision colon, first proviso colon. Exact same scenario where after a colon, a proviso came up for discussion in that famous section 24(2) interpretation, my lords. Justice Arun Mishra's bench, heading Constitution bench on indoor municipality, your lordships will remember. The question was, does that second proviso, does it attach itself to the proviso just above it, or does it go to 24(1)? The answer given, we have annexed that also. Answer given was it attaches itself to what immediately precedes it. So if you were to interpret 200 in that sense, let me just give your lordship what I believe the answer is. I've put a chart which shows how that sequence flows. And let me just explain it for half a minute. There are 5 provisions, all of which were referred to by Mr. Amit Kumar, the Advocate General, who just spoke before me. 5 provisions in which there will be reservation for the consideration of the President. Only 5. Just to answer Justice Narasimha's question about the distinction between the use of the word act or law in 254(2) versus bill, which is used in 200. That is answered in Kameshwar Singh in majority, and it's followed in Valluri once again, saying that it makes no difference whether it's bill or act which is used, because the word used in 200 is bill. In those other 4 provisions, the word used is law. But they say it makes no difference. Therefore, there are 5 specific provisions, including the second proviso, where bills or acts are reserved for the consideration of the President. Barring those 5, the interpretation of 200 is clear. Every single bill gets assent. Every single bill gets assent. The question is when. Either you get assent immediately, or you withhold it for it to go back to the legislature. And once it comes back, you can't withhold assent. There is no other option. You have to give assent. That's the answer. In my view, there is no doubt about it, because that is exactly how it flows. So if your lordships note the flow of Article 111 with reference to the President and read it with this, 111 has only 2 options. It's assent or withhold. Here, if you consider the fact that there is money bill, if you consider the fact that there is reservation for the President, and the fact that if you see the words once again, which have been used after the presentation, if I can just read that first proviso, provided that the governor may, as soon as possible, after the presentation to him of the bill for assent, which means if you see the first proviso, it is clear that it is for assent. The words
That
are,
is what Mr. Amit Kumar also argued, that he said that we have to read the marginal note.
Yes.
no, I'm not on the marginal note. I'm on the first proviso.
So
It
according
says,
to-
provided that the governor may, as soon as possible, after the presentation to him of the bill for assent. It's not for any other purpose. It's only for
That's
assent.
what Mr. Amit Kumar also argued.
Very well.
We have already taken 20 minutes.
But I have 3 more,
No, we have to,
submissions. Because,
we have to give time at least 10 minutes each to the others.
may I just make one submission?
You
Your
conclude it.
lordships have heard, your lordships have.
No,
heard
as
the
an intervener, we have sufficiently heard you.
No, I know, but I'll just take 2 moments. I'll just take 2 moments. Now, I'm skipping the justiciability part of it, but I've mentioned, if your lordship will just take the note, then I'll finish in 2 minutes. Just see 5.4, middle of the page, point 5.4. It gives your lordships the reasons
Page-
why, page 1359, 1359.
Yes.
1359, 5.4. If your lordship sees, I've given 5 instances in the constitution where if the governor refuses to swear in a chief minister, president withholds issuing a warrant of appointment of a judge, governor does not lay annual financial statement. All these instances, your lordships will step in, because the question always being put is these are not instances in which you will step in. There are multiple instances which can occur. Thankfully, they've not occurred, but multiple instances where it will be demanded that there will have to be a neutral authority who steps in and plugs that issue. That has happened in this particular case. We have given 2 full annexures, if your lordship will see page 1360. Appendix 8 and Appendix 9 are multiple instances, my lords, where your lordships have stepped in. 1360, if your lordship sees 6.1 and 6.2. Series of instances where, with reference to speaker's decisions, with reference to Article 161, etc., your lordship 324, appointment of the Election Commission, you have stepped in. On timelines, apart from the speaker judgment, the second judge's case, Scora, your lordships impose timelines on yourself. That has not been read to your lordship. Please read the concluding part of Scora. Timelines of 6 weeks, 4 weeks, 1 month, etc. are put on every authority there, which is President, Governor, and Supreme Court. So, a put on high authorities should not come as a surprise. It's happened repeatedly in the past. My lords, with reference to 145.3, just want to answer one question that Justice Narasimha had put yesterday. If you see 145.3, it is only dealing with this part, and it's dealing with appeals. 145.3, where it says refer it to 5 judges, which tells you the number of cases you have pending. But as far as the state of Tamil Nadu case is concerned, because that point was taken, saying that they had asked for a reference, there is no mandate in writ petitions, Article 32 writ petitions, for the framing of this question. Because that wasn't there, because 145.3 doesn't apply to, the 145.3 proviso does not apply to Article 32. It doesn't fall in that part at all. That's one last point I wanted to make. Well, I think there's more to be said, but I hope my written submissions will be read. I don't want to take any more of your stuff. I'm good.
Yes, Ms. Bansal is before you.
Lordship, may I say?
She is before you in the list. Thanks.
Being that I'm the youngest arguing, my lords may just give me another 5 minutes and
No,
at
no,
least
that's
allow
it.
me
It's-
15 minutes.
There are three left. You, then Mr. Jain and Mr. Sajeva.
At least 15 minutes,
No, no.
that's all I'm requesting.
10 minutes each.
All right. In that case, my lords, I would like to restrict myself to only the question of timelines. My lords, a lot of other arguments and issues have been addressed, and I will, on the question of timelines, make only 3 arguments, which in my humble submission have not been made before. Now, my lords, before, if I had the time, I would take my lords to paragraph wise of my written submission. I've already circulated my written submissions, my 2.9, my lords, volume 2.9 and onwards. Now, my lords, if I may just show you one annexure, which is important that we have put together, which is on volume 9, page number 1221 of my submissions. Page number 1221 of my submissions. My lords, it's a table where we have said and we have argued, my proposition is that there are actually 4 categories of timelines which are running through the Constitution. And the table, my lords, have it on page number 1221 of volume 2.9, annexure 1. Now, my lords may see that there are 4 categories in which the question of timeline has been divided in the Constitution. It's something which is like an undercurrent running through the entire constitutional scheme. My lords, the first category is where no timeline has been provided. And this court has read the requirement of reasonableness into it. My lords, for example, Article 161, mercy petition, We know that no time period mentioned in the constitutional provision, yet the requirement of reasonableness has been read into it. Now, my lords, second example, for instance, paragraph 6th of the 10th schedule, my lords will see, again in Keshav Meghachandra, I know my lords are aware of the facts of the case, it has been referred to several times. No time period, my lords, in paragraph 6 of the 10th schedule, and yet my lords read the requirement of reasonable period. My lords, so this is the first category, and there are more, where the or any word suggesting timelines, and yet the courts read into the requirement of reasonableness. Now, there's a second category, where there are specific timelines mentioned in the Constitution itself. It's a long list, my lords, but for instance, Article 123, subclause 2, Article 213, subclause 2. For example, that the ordinance must be laid before the legislature and that it will cease to operate 6 weeks after reassembly unless approved. The table, since this is a point which requires least consideration, I'm not going to focus on the second category. If there's a specific timeline, you ought to follow it. Now, there is a third category, my lord, and my focus is that there is an attempt, while we're discussing as soon as possible, not enough has been said, my lords, on as soon as may be. And that is my first major argument today. That there is a third category called as soon as may be. And my lords, there are 17 times that in the Constitution, the phrase as soon as may be has been referred. And then there is a fourth category right next to it, my lords, which says as soon as possible. Now, my lords, in the interest of time, I will just refer to one particular paragraph, which will bring out the difference between as soon as may be and as soon as possible. My lords may kindly have, my lords, my written submissions, so volume 2.9, page number 1203. Page number 1203.
Yeah.
My lords, I've also included it in the drive. So if my lords are looking at the drive, it's volume 5.641. My lords have it. My lords, volume 5. Just look at my submissions, page number 1203. Yes.
From 1203.
Very well, very well. Now, my lords, this is a judgment, Ram Kishore Arora, 2023, INSC, page number 10821. And my lords, if I may quote, paragraph 19 and 20 of this judgment. I quote, in view of the above, the interpretation of the expression as soon as may be assumes significance. In our opinion, the interpretation of the said expression should not detain us more in view of the Constitution bench judgment in the case of Abdul Jabbar Butt and another versus State of Jammu Kashmir. In the said case, my lord Abdul Jabbar Butt, while interpreting Section 8 of Jammu and Kashmir Preventive Detention Act 2011, had an occasion to interpret expression as soon as may be, and it observed thus. My lords, this is the key operational part. The observations of Justice Dysint in Carbononic Corporation Limited quoted Stroud's Judicial Dictionary and said, to do a thing as soon as possible, my lord, they are also distinguishing it. I mean, they're using both as soon as possible. As soon as possible means to do it within a reasonable time, with an understanding to do it within the shortest possible time. Maybe, may well said to mean to do so within a reasonable time, with an understanding to do it within the shortest possible time. Now, when we read those two sentences, it looks like the same thing is being said, which is why we ought to read further. The words as soon as maybe came for consideration before this court in Ujagar Singh versus State of Punjab. And at page number 76162, this court observed that the expression meant with a reasonable dispatch, and then went on to say that what was reasonable must depend on the facts of each case. My lords, may kindly just, my lords, page number 1204 of my submissions. My lords, there a phrase is used which will give us the key of distinction between as soon as maybe and as soon as possible. And I quote, my lords, it's highlighted on page number 1204, first paragraph. The words as soon as may be in the context must imply anxious care on the part of authority concerned to perform its duty in this respect as early as practicable without avoidable delay. So, my lords, my submission is that it is not by chance that the phrase as soon as may be has been used 17 times. And as one of the learned counsel submitted before me, the word as soon as possible has been submitted 7 times. And now my submission, my proposition, my lords, is all of these cannot be just thrown into a reasonableness requirement which is amorphous and malleable. So in cases where there is no time requirement, my lords, say reasonable period, and rightfully so. But where there is as soon as may be, there is reasonable period. But then when there is as soon as possible, if my lords, we still rely on reasonable period, then what is the import of the words as to my second argument? That my lords have a historic opportunity, in my humble submission, to lay down, at least at the bare minimum, that the words as soon as possible as a meta principle have a higher lines provided in the Indian Constitution. My lords, right now I'm less so on the specific timeline. I'm just going to come to it in 1 minute's time. But my major argument, my lord, is that this is an opportunity to remove this confusion and say, while reasonable requirement is underlying all these different categories of timelines, but as soon as possible, my lords, which is used 7 times in the Constitution, has to mean more than as soon as maybe, and therefore has a higher threshold, and therefore a more expediency requirement as compared to as soon as maybe. That if my lords accept this argument, that as soon as possible is a higher threshold, that still begs the question that can this court, and I mean, we're looking at the Tamil Nadu judgment while this is advisory, but this question is before my lords, that can specific timelines be laid down? So can the court decide 1 month, 3 months, so on and so forth? And I also ask myself the additional question that what will be the ramifications of that when as soon as possible comes up in other places in the Constitution? So for example, can this court then be laying down specific timelines in other places also where as soon as possible comes up? And to that, my lord, I have twofold submissions. My first submission vis-a-vis specific timelines is this, my lord, that my lords have ample power under Article 142 to do complete justice, and that is not a limited power to lay down timelines only in specific cases. My lords, it is true, and I acknowledge humbly that every time this court has laid down timelines so far has been specific to the facts of the case. But I am suggesting, my lord, that under Article 142, there is nothing to prevent my lords to also lay down systemic guidelines, except 2 things have to be seen. The first thing, my lords, when laying down systemic guidelines for time to come is, the first question is that whether this timeline is consistent with constitution provision and it's not violative of any other statutory provision, which in this case I'm suggesting that putting in the 1 month requirement, going back to my argument, because of a higher threshold of as soon as possible, is in no way substantially, is in no way going to change the nature of Article 200 and 201. And because of that, my lords, read with Article 142, it is my humble submissions that my lords, once they lay down that as soon as possible is a higher threshold, then Article 142 can permit them to lay down systemic guidelines for time to come, as long as my lords also hold that this 1 month, 3 months time period is not going to change the substantial nature of Article 200 and 201, which it is my submission that it does not. And the second argument, my lords, I mean, going back to IC Golaknath and another, we know that Article 142, it was held in IC Golaknath, has been used to evolve legal doctrines to meet the ends of justice. My lord, that primarily summarizes my first argument. As soon as possible is a higher threshold, distinct from as soon as maybe, cannot be thrown into an amorphous reasonable period. And second, read with 142, there can be systemic timelines. Now, my lord, that brings me to my second question. And I know that, my lord, this might sound new or out of place, but I request my lords to indulge me for 2 minutes by the watch on this argument. My lords, this debate.
You have to conclude within 2 minutes.
My lords, hear me. Allow me 2 minutes to. If my lords entertain this argument, I will go forward with it. But I need to speak this argument and speak my truth, so to say. My lords, in this debate between the legislature and the executive, the question is, I say this with respect, that the citizens of India are not a sitting duck. For example, just one illustration in the interest of time. I come up with a list of illustrations, but just one illustration. Well, let us say I come from an area where for around 100 kilometers, there is no government hospital or no government college. As a citizen in a democracy, I petition the government. The government says I do political lobbying. I use all my democratic means. The government says, yes, we have passed the bill. And then it sits with the governor or on the governor's desk, government or the political party in power, whichever. Now, at this point, if for the next 3, 4, 5 years, if that bill does not pass, then as a citizen, I have absolutely no voice. So it is my proposition that this advisory opinion, 5 judges bench, my lords, is also an opportunity to perhaps consider that it is time to recognize right to time as a concomitant right under Article 14. My lords, if the governors or the presidents do not act as constitutional functionaries in the time threshold that they're required to, irrespective of specific timelines, because we have said as soon as possible is a higher threshold, then my lords, it is an arbitrary act. And we have a series of judgments saying that arbitrariness and equality are sworn enemies. My lords, I have referred to a lot of judgments. I will just read one judgment, my lords, on this. My lords may kindly have.
When ready to just tell us the pages.
Yes, my lords, page number 1216. I'm just going to read it. My lords, Article 14, I'm reading Maganlal Chaganlal because, my lords, this is a 7 judges bench judgment. Article 14, page number 1216, last line, my lords, of my written submissions. Article 14 enunciates a vital principle which lies at the core of our republicanism and shines like a beacon light pointing towards the goal of classless egalitarian socio-economic order, which we promised to build for ourselves when we made a tryst with destiny on that fateful day when we adopted our constitution. If we have to choose between fanatical devotion to this great principle of equality and feeble allegiance to it, we would unhesitatingly prefer to err on the side of the former against the latter. I've also quoted Menka Gandhi right below, my lords, in paragraph 51, where we are saying Article 14 strikes at arbitrariness.
Go through it, yes.
Yes. So, my lord, my argument is that if governors and presidents do not act in time, irrespective of that specific timeline, but they don't act as soon as possible, then, my lords, as a citizen of India, do I have no right? My lords, in multiple cases, right to privacy, right to media.
Thank you now.
My lord, just allow me just 1 minute to wrap my argument. Yes, my lords, 1 minute by the watch to wrap my argument.
You
I'm only saying,
have very well utilized your time. You have recorded your argument.
my lord, just one last argument. Right to time. It cannot be taken lightly because I'm requesting my lords not to just say something in the obiter. I am requesting my lords to say concomitant right. It is about time. Otherwise, my lords, all these 4 categories of timeline will mean nothing, irrespective of how much pen and ink is drawn on the pages. Very grateful, my
Thank
lords.
you, thank
Thank
you.
you very much.
Compliment for the young lawyer.
Yes, yes.
Thank you.
Very well utilized your time.
Timeline was good.
I'll just take 1 minute at the end.
Yes, it's there.
Yeah.
That's your motto.
Lordship, I will start
Survive.
only the new points which are
Yes,
not discussed till now.
Yes, please,
Yeah.
tell us what are your.
Yeah. In Article 361, President and governors are given protection in criminal and civil matters only, not in the constitutional matters. Now, by the virtue of the clause 1, proviso 2, if any constitutional wrong is done by the president or the governor, then the president or governor will not be prosecuted or punished by this honorable court, but the prime minister with Union Council of Ministers would be prosecuted and punished by this honorable court for any constitutional wrong. Second, in this constitutional court have power not only to correct the constitutional wrong, but also to prosecute and punish the persons liable for that constitutional wrong. It is the hidden power which our constitutional makers provided in Article 361. Now, our constitution makers never want that India should be governed by a dictator or the Hitler type of person. Because, Lordship, I will take only 1 minute in the constitutional history of that proviso. Our constitutional makers also seen the Second World War at that time, and they are also affected the devastating effects of that. The Hitler was also the one reason of that war at that time. I am not going the plus and minus of any politics. I am just saying only 2 things regarding the Hitler that are directly connected to this proviso.
Is there any discussion in the Constitutional Assembly debates with regard to Hitler?
Is connected to this constitutional court power, so that's why.
Is there any debate?
Lordship, it is just, you can say, when I will speak, it is the intention of our constitutional makers and they are totally affected, and it is also in certain political and constitutional books, it is also mentioned. What I will say in 2 or 3 lines only. Hitler was the political leader. He was not a dictator initially. In Germany at that time, there was a Nazi party. He was elected to the leader of the Nazi party in the democratic way and become the chancellor by the Hindenburg. But at that time, he kills the democracy in his own political party, and suddenly he misused all the parliamentary and the constitutional provisions and misused them and become the dictator in the Germany. Our constitution makers who borrowed the constitutional provisions from the different world countries also have the fear at any time can it be possible in the Indian democracy, can a leader elected by the democracy and by the votes can be converted into a dictator? Can it be possible? That was the question also in their mind. So that's why they provided this proviso. This constitutional court have no.
Veda and the Leonardo, please don't interrupt. He gets disturbed.
Look, we are internally discussing, my lord.
Don't
For
discuss
the
that.
first time in the history of this court,
Yes.
Hitler is, my lord, coming
Yes, yes.
according to him to
Yeah,
the need of constitutional
Lord, it's
interpretation.
taken our time, so please,
Yes.
please, can I
Yes,
continue?
conclude.
Lord sir. So the constitution, we have the democracy, and our constitution makers have the fear that one time can any elected political leader can be converted into a dictator. So that's why this court have the power under Article 142, that is the enhanced power, that is a different thing. They also in this provision provided this power to this constitutional court. And even now there can be the question, then who can come to this court? And by the virtue of this provision, any Indian citizen, any person can come to this honorable constitutional court. And it is not necessary that a political party should come. It is clearly mentioned in this provision.
So who is saying that no person can come? Who is saying that a citizen is precluded from coming to the court?
Provided further that nothing in this clause shall be constituted as restricting the right of any person to bring the appropriate proceeding against the government of India and the government of the state. So that's why. If I can give the one example. If in 20 or 25 states, the government of the one party, and in the 4 or 5 of the opposition party, and if the continuous rule of the particular person is going on years and years, decades and decades, then what will happen? Who will bring out from the clutch of that person this constitutional? There are citizens of two types who cast the vote, and second, under the 18 years and the children in the womb of the mothers, they also have the right to the democracy.
You have 2 more minutes.
Yeah, so,
conclude.
Lordship again. Now the clause 1 is limited when it says that the president or governor shall not be answerable in the court. Never means that power or duties of the president or governor cannot be explained or defined, or vacuum cannot be filled, or writs cannot be issued by this honorable court. That means these writs can be issued to the president and the governors regarding their acts, duties, and the rights. That is the constitutional explanation of the Article 361, which are left. And now, Lordship, I will come to Article 111. In that, I will touch only one thing. Indian president have the power of pocket veto only in one condition. If the central ministry is shaky or is about to collapse, not in any other case. Suppose if an ordinary bill is passed by the parliament and the president have the reason that it will collapse shortly, or the government have not majority in the house, in that case, he can use the pocket veto and keep the bill on his desk indefinitely, otherwise not.
Not indefinitely, till the new assembly.
Yeah, the new assembly or the new parliament will come, and that will take the decision on that.
Thank you, Mr. Chairman.
Lordship.
No, thank you. 10 minutes over. Who is next,
Grateful to all.
Mr. Sajdeva or?
My lord, I'm appearing in IA number 198588. My lord, I have filed a petition in Chhattisgarh High Court on the same issue, that one bill passed in 2022 has not been either declared assent or nothing has happened, just sitting over it. So I have a locus here also. So my lord, most of the things have already been covered.
Yes.
What I would like to point out, that there are three principles: constitution is supreme, will of people must prevail, and rule of law. So the rule of law requires enactment of new laws, and that is, in my humble submission, is an essential and urgent business, urgent function. That is why the provision of promulgating ordinance is provided in the Constitution. So a law which cannot even wait for a house to sit and decide, if in a given emergency situation required, then it could be promulgated under Article 123 and 213. So there is a time limit. The essence of time is there because these articles are there. You don't even wait for a house to sit and pass. Now, on Article 213, there is only one proviso in the main part, which requires precedent consideration, precedent recommendation. There is no corresponding proviso as regard to Article 200, the first proviso, which gives withheld. So something which is not there in 213 and there in 200 can't be interpreted in a manner to provide a pocket veto or withhold indefinitely. Just suppose a situation, an ordinance is passed, promulgated, and after 4 months, House sits, pass the same bill, can governor withhold? No.
That is already been argued. If you want to argue something,
Yes,
you will tell us.
just my lord. The second thing is as soon as possible. The query has came.
He has very beautifully argued just before you.
The query has
As
come
soon as possible.
that in as soon as possible, the suggestion with regard to not later than 6 months is not agreed. My lord, may kindly have a look at Article 62 and 68, which is with regard to election of president and election of vice president. In 62(2), when a casual vacancy occurs, the article says as soon as possible, but not later than 6 months. But in the case of 68, the election of vice president, the article says as soon as possible only. Does it mean that election of vice president is less important? As a matter of fact, vice president chairs the Council of State, Rajya Sabha. So the session may be within next month or after 2 months. So this as soon as possible shows more urgency. It doesn't allow you to sit for 6 months.
Yes.
And my lord, the electoral college is also made different for this. The president electoral college involves legislatures, whereas the vice president electoral college is limited to only 2 houses.
Yes, how is that relevant in this?
Because the election has to be completed in a sooner better. I am just substituting my earlier argument. That as soon as possible shows more urgency, where it is used only without any time period. So in Article 200, when it was not agreed to, not later than 6 weeks, it doesn't mean that because after passing of bill, there are instances when in 2 days, 3 days assent is given. So my lord, the next point which I would like to raise is with regard to providing timeline. An example was given that trials ke liye timeline was given, but it couldn't be adhered. Trial can go on, and this court has to grant time extension. That situation is not akin to this example. In my humble submission, a trial is akin to when the bill is in the assembly. It could be passed same day, it could be sent to some select committee. So we cannot assume in how many days the assembly house would pass the bill. But once it is passed, the situation is akin to reserving the judgment. And my lord have provided that within 3 months after reserving the judgment. And this timeline, because in the whole scheme of the constitution, 5 years for assembly, 5 years for president, vice president, Lok Sabha. There are instances as 2020 bill passed in some state and is still pending. And what is happening in my state of Chhattisgarh, one bill passed with regard to change of university name. Just the change of name that was not given assent. My lord, the third aspect is whether the petition 32 is maintainable.
Are you a state government?
No, my lord. What I'm
This condition is the petition at the case of the
what I'm trying to say, I'm just addressing that aspect. Once my lord holds that withhold simpliciter is not there, that is the key. If my lord holds that withhold simpliciter is there, then everything goes. Once my lord holds that withhold simpliciter is not there, then the Council of Minister advice has to be followed, except in the second proviso, what is there in the 200. Even in case of repugnancy, Council of Minister recommendation is required to send to President. That is my submission. What I am saying, that violation of Constitution is ground for bringing impeachment for President. But there is no impeachment provision for vice governor. Governor holds office at the pleasure of president. That's all. Then if bill is not given assent to, then it's a violation of constitution. Then what is the remedy? And
So you can conclude with your 1 minute. Yes.
my lord can add that if not state, then leader of the house in the representative capacity can file a 32 petition.
Just
Yes,
a moment. Lord, I've taken permission for Andhra
But
Pradesh.
I'm extremely grateful, my lord.
Thank you.
Lord, on issue, Lord, we have supported the union on all stands, except and including the stand that Article 32 may not lie against the governor. But to say that 32 will not lie in all cases by state law, that is something which we cannot countenance because water issues, pollution issues, man-made disasters, and writs are pending. So let that issue not be gone.
But nonetheless, he is a part of the legislature because the Lord, it cannot be taken, my lord, in that strict jacket, rejoinder, reply, rejoinder argument.
Because it's not a list, my lord. Because it's not a
It's
list.
not a list, my lord. It's
Therefore,
not
there
a
is no
list.
rejoinder, but I
agree with
think
my
we
lord.
should
It's
not
a
object
list.
if the
According
solicitor
to
wants
it,
to.
it's only an opinion,
No, my lord.
not binding on anyone.
Lord, I would not
It is a report.
reduce.
It is a report.
But we have had the perspective of two extreme views taken and argued by the two sides.
Your lordships are
The
right.
balance, we will have to bring it.
Yes.
I think we have seen the extreme views from both
Correct,
sides.
correct, correct. My lords, your lordships may, my lord, find
It's a very enormous task that we have.
your lordships, my lord. Therefore,
And the task of 18,000 pages.
that's my lord, that's a Herculean task.
Unfortunately, there is no summer vacation in between now and 24th November.
Yes, my lord, there is none. My lord, and your lordships.
The attorney has contributed only very little part of it. I said, I have contributed only very little part of it.
Yes. Pages have gone up to 25,000, not 18,000. 25,000. Volume 5.62.
But, my lord, to be fair to everyone, we have not, none of us, my lord, have cited all judgments which are placed on record. My lord, possibly they are placed on record in case, my lord, it is required to be cited.
We are told of constitutional silence.
Yeah, yes, my lord. My lord, volume 1.9 may be taken, my lord, and I can assure your lordships, I am not going to read everything. I'll skip most of the paragraphs, but they are my submissions, my lord.
Another volume, no?
Yeah, my lord, it's a
Rejoinder volume.
rejoinder volume, my lord, a response, or my lord, I have termed it as a rejoinder.
Rejoinder submissions on behalf of the solicitor. Got it.
But this is the central government's interpretation, I'll put it that way, to the interpretation canvassed by some of the state governments. My lord, and I would, my lord, respectfully say, I would not reduce the august jurisdiction of this honorable court, that is advisory jurisdiction, of a mere giving a report which is not binding, which is not worth a piece of paper. My lord, no. Your lordship's opinion, Lord, is a law declared, and I'll make that good. And your lordships can even declare, I'm repeating, your lordships can even declare that this particular judgment or the view expressed does not lay down the correct law. Your lordships can even overrule that. It's not just, my lord, a communication or conversation between the President of India and the Supreme Court of India. My lord, the President of India has, my lord, my lord, has sought your lordship's opinion, and your lordships are interpreting the Constitution while giving that opinion. My lord, kindly come to page 746. My lord, these are the broad propositions, my lord, which are argued, and I'll deal with it, my lord, without repeating anything, my lord. And if your lordship finds any repetition, your lordships may, my lord, kindly tell me. I'll proceed further to the next point. My lord, the argument number 1, governors have no power to withhold a bill in any circumstances whatsoever. Number 2, the governor has no discretion in any circumstances whatsoever under Article 200, meaning thereby, the moment the bill is presented before him, in every situation, he is supposed to act in aid and advice of the Council of Ministers, meaning thereby, if I put it, paraphrase it in my own way, they have not argued in that way, that he is a postman with only two difference, that his car has a beacon and he has a bigger house. That's, my lord, constitutionally a flawed argument. Third, the governor, therefore, is not to apply his mind to the process. So this was an argument made. The action of the governor is judicially reviewable to the fullest extent. My lord, I have certain constitutional submissions to make, my lord, before your lordship, my lord, which I have already made, but some additional submissions, my lord, which I make, that it is not amenable to judicial review. Even if it is amenable to judicial review, it is not justiciable. And I'll give the reasons, my lord, in a nutshell. The governor is answerable like any other executive authority making any other routine administrative executive decision. My lord, this is again, my lord, in my respectful submission, constitutionally not correct, because as I'll show, my lord, from the scheme of the Constitution, the legislative process starts from a particular article, my lord. Thereafter, it comes to introduction of the bill. Thereafter, how the bill travels, and it ends, the legislative process ends with the assent of the governor. Your lordships are aware, the governor is a part, he is a component of the legislative assembly, but he has no right to vote. He cannot preside over the meeting. But nonetheless, he is a part of the legislature because the legislative process commencing from introduction of bill culminates into the final step of legislative process under Article 200 when he gives his assent. And the last, the governor must act within a set time frame as provided for by the court absent any constitutional provision. My lord, kindly turn the page over. My lord, I have, my lord, already narrated, but I am emphasizing, my lord, this oath of office, my lord, because your lordships are considering the powers, functions, duties, responsibilities, etc. of the governor. And there is one judgment which is not so far cited, for which, as a prelude, I would like, my lord, your lordships to see which oath the governor and the president takes, which is, my lord, these are the only two functionaries for which, my lord, this specially defined oath is, my lord, contemplated in the Constitution, Article 159. I so and so do swear in the name of God that I'll faithfully execute the solemn affirm office of governor of so and so, will to the best of my ability preserve, protect, and defend the Constitution and the law. Lord, my first respectful submission is that there are certain implied discretions, which I will come to, my lord, little later. And one of the implied discretion, my lord, would flow from his duty to preserve, protect, and defend the Constitution. Lord, now, please, my lord, come to Article 167, which is quoted at page 747. It shall be the duty of the chief minister of each state to communicate to the governor of the state all decisions of the council of ministers relating to the administration of the affairs of the state and proposals for the legislation, to furnish such information relating to the administrations of the affairs of the state and proposals for legislation as the governor may call for. He can even ask this how this particular government is functioning. And I'll, my lord, show Supreme Court, as your lordships have said, why this is the power conferred upon you. See, if the governor so requires to submit for the consideration of Council of Ministers any matter on which a decision has been taken by the minister, but which has not been considered by the council, he can say that such a decision of this magnitude, decision affecting the entire state, or decision affecting the economy of the state could not have been decided by one individual minister, place it before the cabinet. Lord, these are the responsibilities of the Honorable Chief Minister of the state. Lord, now in this context, please read a Constitution Bench judgment which is so far not read, my lord. That is case of BP Singhal versus Union of India. Page 748, my lords. Lord, your lordships may see para 35 of this judgment. My lord, last line, which nothing, my lord, says much, it says the constitutional position. He thus occupies a high constitutional office with important constitutional functions and duties. Now, please see further. In state of Rajasthan versus Union of India, my lord, please mark, this is a 7-judge bench judgment. A constitution bench of this court described the proposition of the governor thus: the position of the governor as the constitutional head of a state, as a unit of the Indian Union, as well as the formal channel of communication between Union and the state government, who is appointed under Article 155 of the Constitution by the President by warrant under his hand and seal, was also touched in the course of arguments before us. On the one hand, as the constitutional head of the state, he is ordinarily bound, please mark, my lord, the argument was that he is always bound. 7 judges bench says, ordinarily bound by reason of a constitutional convention by the advice of his council of ministers conveyed to him through the chief minister, barring very exceptional circumstances among which may be pointed out by my learned brother Justice Bhagwati and Justice Krishna Iyer in Samser Singh case, a situation in which an appeal to the electorate by a dissolution is called for. On the other hand, as the defender of the Constitution, look, this is why I read the oath he takes, as a defender of the Constitution and the law and the watchdog of interest of the whole country and well-being of the people of his state in particular, the governor is vested with certain discretionary powers in exercise of which he can act independently. One of his independent functions is making of report to the union government, on the strength of which the presidential power under Article 356 of the Constitution could be exercised. Insofar as he acts in the larger interest of the people appointed by the president to defend the Constitution and the law, he acts as an observer on behalf of the union and has to keep a watch on how the administrative machinery and each organ of the constitutional government is working in the state. Unless he keeps such a watch over all governmental activities and the state of public feelings about them, he cannot satisfactorily discharge his function of making the report which may form the basis of the presidential satisfaction under Article 356(1). My Lord, here the 7-judge bench reads the implied discretion that under certain circumstances, as a watchdog, as a representative of the union, as a representative of the president, he will have to have certain discretionary powers, and one of the illustrative power is Article 356. But further, Lord, this BP single sides state of Karnataka, Lord, another 7-judge bench judgment, Lord. The governor of a state is appointed by the president and holds office. By state administration is carried on by him, etc., etc. My Lord, your lordships, my Lord, kindly see there are, my Lord, your lordships can skip 38. 38. Another constitution, this is all quoted in BP single. Another constitution bench of this court in Hargovind Pant versus Raghukul Tilak. My Lord, please see, my Lord, only the highlighted part. My Lord, I have quoted everything so that I am not accused of selectively quoting, but what is relevant for the present purpose would be, my Lord, in my submission, the highlighted part. The governor is the head of the state and holds a high constitutional office which carries with it important constitutional functions and duties, and he cannot, therefore, even by stretching the language to a breaking point, be regarded as an employee or servant of the government of India. My Lord, not in these words, but my Lord, Dr. Singhvi virtually said that he is just, my Lord, a nobody who is sitting there on behalf of Union of India. He is not amenable to the direction of the government of India, nor is he accountable to them for the manner in which he carries out his functions and duties. He is an independent constitutional office which is not subject to the control of government of India. He is constitutionally the head of the state in whom is vested the executive power of the state and without whose assent there can be no legislation in exercise of the legislative power of the state. Grant of assent is exercise of legislative power of the state. And this would be relevant, my Lord, when your Lordship are pleased to examine the justiciability and locus of filing writ petitions which is conferred by, my Lord, this Honorable Court. There can therefore be no doubt that the office of the governor is not an employment under the government of India, etc. 5 is important. It is impossible to hold that governor is under the control of the government of India. His office is not subordinate or subservient to the government of India. He is not amenable to the directions of the government of India, nor is he accountable to them for the manner in which he carries out his functions and duties. Then, my Lord, Rameshwar Prasad is quoted my lord, this is again, my lord, constitution bench, but I'm skipping para 39 and directly coming to para 40. My lord, this would be, my lord, assisting your lordships, my lord, immensely. It is thus evident that a governor has a dual role. The first is that of a constitutional head of the state, bound by the aid and advice of his council of ministers. My lord, I am not disputing. Normally, ordinarily, the governor will have to act in aid and advice of the council of ministers. As my lord stated by Mr. Singhvi, he is not a super chief minister, neither expected to be super chief minister.